birthday.
Oh, I'm not going to say anything on the record because he asked me not to. Good morning, ladies and gentlemen. I detect a quorum, and we're going to get going here because we've got more important speakers again today. Appreciate very much y'all being here. I figure we may have a few absentees because the governor's going to make a big announcement down in Lynchburg today about a particular plant expansion, and so we're with them in spirit, but our minds are here, right? We're going to. Thank you for noticing that. We're going to continue behind tab 4. Today we're going to have our municipal panelists, and they've been rehearsing. I came upon them late yesterday afternoon, sort of going through their repertoire. They've got a team approach. They've a tag team approach in a way, and unlike what is in our notebook, we're actually going to start with Mayor Wilbur. But I'd like to invite everybody to come up to the table as we did with yesterday's panelists. So as we say, come closer. And then you can feel free, please, to speak from the podium. Good morning. I'll just, for the record, so folks watching here today will know, our municipal government panelists include Mayor Tom Bickers, and people want to know if it's Louisville or Louisville. In Tennessee, it's Louisville. This is not. They pronounce it Louisville in the state north. We're Louisville. Exactly. And folks learn something new every day. City of Kingsport, Assistant City Manager Jeff Fleming. Glad to have you here. City of Covington, in my district, Mayor David Gordon from Tipton County. The City of Alcoa, Assistant City Manager Bill Hammond is here. And finally, from the City of Portland, Mayor Ken Wilbur. And the last shall be first, because I understand, Mayor Wilbur, you're gonna take the lead. You are recognized. Good morning.
All right. Thank you again. I appreciate it. And I'm Mayor Ken Wilbur. I'm Mayor of the City of Portland and immediate past president of the Tennessee Municipal League. Mr. Chairman and Commissioners, thank you for this opportunity to share our thoughts on these very important issues. In an effort to cover the waterfront and avoid repetition, we're going to take a team approach. So if it meets with your approval, I would like to defer to Mr. Fleming, who will be followed by Mayor Gordon and others, and then I will conclude the panel. Mr. Chairman, if you don't object, I'll defer to Mr. Fleming to begin.
Without objection, none at all. Go ahead. Good morning, Mr. Fleming.
Good morning. How are you?
Fine, thank you. Thanks for joining us.
Well, thank you for the opportunity. I want you to know I respect and admire each and every one of you for being willing to do the job that you do. I know that you don't do it for the money. You do it because you love the places that you come from and you love this great state. And I just appreciate your willingness to serve. My name is Jeff Fleming. I'm in my 29th year of service to the City of Kingsport. I've worked my way through the ranks from my current position to my current position of Assistant City Manager for Development. Perhaps I bring a unique background in that my master's thesis was based on the topic of annexation at East Tennessee State University. My first job duty in 1985 was literally to go door to door selling the benefits of being annexed, analyzing personal financial implications, collecting signatures, and establishing boundaries based on the results of that polling. I've seen just about every form of annexation during my tenure. Kingsport has annexed nearly 20,000 people in all socioeconomic groups and has faithfully invested tens of millions of dollars into urban services like water, sewer, schools, sanitation, police, and doubling the number of fire stations with round-the-clock firefighters and paramedics. Annexation shouldn't be about cherry-picking higher-income neighborhoods. It should be about figuring out the most efficient way to provide urban services to all neighborhoods. I represent a subgroup of TML charged with reviewing Public Chapter 1101. Our subgroup is made up of a cross-section of elected and appointed officials from all 3 grand divisions. I know as a city official you can predict what I'm going to say about annexation, and you're right, but I hope to be able to reframe it a little bit so you can view it through a different lens. I absolutely love selling Tennessee as a high-quality, low-cost place to live, work, play, raise a family, develop a career, retire, and spend that lifetime of accrued wealth here. In fact, Tennessee continues to win award after award for all of these attributes. More than 3,000 families from all 50 states have relocated to my community alone in the past 7 years. I can only imagine how that multiplies statewide. I often hear about the incredible affordability of property taxes, utilities, housing, and many more. They're leaving states with fragmented government, duplication of effort, inefficient provision of services, severely diminished economies of scale, unionized labor, and many attributes that we don't want to emulate here. The state's growth policy sets the framework that will either improve Tennessee's competitive position or that will continue to become like every other state. Limiting annexation to referendum sounds very simple on the surface, but the ripples will have lasting consequences. County government historically exists to provide state government services at the local level. Services like courts, deeds, licenses, jails, schools, roads, etc. Cities exist to provide the additional urban services that are required when people willingly choose to live in close proximity to each other. Services like water, sewer, fire protection, police protection, sanitation, and the like. These services are absolutely necessary to facilitate economic growth. And for most Tennesseans, cities are the ones who provide those services. This layering of responsibility explains why city taxpayers also pay county taxes. And that is a position that I staunchly defend when taxpayers ask me why they have to pay both. There's a role for each. As rural areas become urban, the logical and efficient provision of services and who provides them becomes a necessary policy of state legislators. Some states chose utility districts, townships, and multiple layers of government and special districts. Tennessee has chosen to allow existing cities to grow within reason. The result is that Tennessee is one of the lowest cost of living states with the lowest cost of living and one of the most business-friendly states in the Union. The flexibility afforded in 1101 ensured the voices of the residents of every county and municipality were represented and the growth plans adopted reflected the priorities and preferences of each county. Complicating a city's ability to grow and provide urban services will lead our state down a path chosen by many other states into associated higher costs of providing services. Whether or not an urbanized or urbanizing area needs urban services is not a question of the current property owner. It should be orderly, planned, and non-emotional because it will impact every family who ever lives in that house, not just the window of time that we're currently talking about, long after the existing voter. Hence, some time ago, Robert Lovelace, a consultant for the University of Tennessee, said that residents have already voted in the most significant way in choosing the location of their home. There must be a logical, orderly progression to plan for growth and the extension of services. Otherwise, Tennessee will erode its highly desirable status and risk its competitive advantage. Before 2000, before Public Chapter 1101, annexation in Tennessee was contentious, litigious, and divisive. Counties sued cities, annexed residents sued cities, larger cities and smaller cities were at odds, tiny towns attempted to incorporate, and judges or juries decided what was or was not reasonable on a case-by-case basis. None of the interested parties could operate or plan with any certainty. The result was fragmentation and inefficiency. Both ordinance and referendum methods were used. Corridor annexations and piecemeal referendums were common. Lengthy stretches of roadway were annexed to stake a claim for future growth. Some cities used people planning, which was a term coined from a court case that allowed those that wanted to be annexed to be accommodated and exclude those that didn't on a house-by-house basis. Services were intentionally afforded or denied based on annexation status. In some cases, pavement stickers were distributed so that service workers could identify those in and out of the city limits in an effort to sort out the provision of services. By human nature, residents are simply unwilling to vote affirmatively in a referendum unless they're faced with a problem that they can't solve individually. When the situation erodes to that point, the cost is exponentially more than it would have been if an orderly plan existed for financing and planning for the provision of services. It's not unlike maintaining your house. If you stay on top of it, you can prevent a small problem from becoming a large one. And it's always better to address a situation in a timely fashion before it becomes a crisis. Public Chapter 1101 was intended to resolve conflicts, establish logical growth boundaries, encourage joint planning for economic development, and determine where and if new cities should be created. One of the important objectives of the Act was to place annexation by municipalities in the context of their growth planning. Planning for the extension of urban services is critical to the state's long-term economic future and the ability to attract and sustain jobs. By and large, cities provide those urban services. Therefore, cities' ability to grow and extend services becomes a key component of Tennessee's economic future. So what is the logical extent of an existing city's limit? What is the most logical, orderly, and accountable way for them to get there? What happens when conflicts arise between cities, counties, and those wishing to incorporate new cities? All of these were admirably addressed in Public Chapter 1101 in a visionary manner that has worked well. Public Chapter 1101 required that all cities and counties sit down together and plan for their collective future. I had a flashback when I walked into this room. In one of the counties, we had to come in for mediation. The other county that we work with, we didn't. We were able to solve it locally. But after careful negotiation, lengthy deliberation, and very few forced mediations, Tennessee's sweeping new growth law and resolved the conflicts previously associated with annexation. Instead of dictating from the top down, these complex issues were resolved by officials at the local level, by those with extensive local knowledge. The process for changing these formally approved boundaries was clearly outlined. If a city asked that its urban growth boundaries be modified or expanded, it required the approval from the county and from all other cities in that county. If any one of those entities said no, then the boundaries remained as is. Once and for all, every property in Tennessee fit into one of three categories: urban growth, planned growth, or rural area. Cities could not be accused of land grabs without properly planning and financing the provision of services in a succinct time frame. Public Chapter 1101 provides a logical way to allow existing cities to grow within those predefined boundaries. It also provides ways to amend or not those boundaries at the local level. The beauty of 1101 is that decisions are made by affected local governments who intimately understand the issues, the budgets, and the implications. Those local governments are elected by the people at arguably the purest level of government. Even though they may not have had a referendum on annexation, annexed residents ultimately become part of the elected leadership. In Kingsport, for example, with the exception of one person, all 12 of the elected members of the Board of Mayor and Aldermen and the Board of Education live in annexed areas. One cannot assume that the issues of Chattanooga are the same as Memphis or those of Medina are the same as Johnson City. The existing law works well for all cities and counties and all sizes, rural to metropolitan. But the right to a popular vote on every growth issue will cripple the state economically. Is there a popular vote on every budget decision, on every capital project? In addition to the flexibility afforded each county and its municipalities to develop and adopt its own growth plan, the law also maintained the prerogative granted municipalities in the 1950s, the exclusive authority to annex property by ordinance. Restricting annexation to referendum only is a very popular path. We had a CEO in our town who talked about leadership moments. I believe that's where we are right now. Tennessee is at a crossroads. When we look back in 20 years, what will we see? More fragmented government, higher cost of living due to duplication of effort and sprawl? Or will we hurry as fast as we can to pattern our laws after those states that people and businesses are leaving to come to Tennessee? Generations of Tennessee leaders on both sides of the aisle have worked diligently to position this state for the economic success and the quality of life that residents are currently enjoying. We currently have 13 years of city-county cooperation under our belts through 1101. We are one of the most desirable states in the Union for businesses and residents, and we got here with the existing legislation. Recently in my city, we had a $1.6 billion investment by Eastman Chemical Company. The CEO said the most important thing that we can do is make ours a place where global talent wants to live. So far, I'd say we've all done a pretty good job of that statewide. Let us continue to do so. In closing, please be mindful that cities and counties are the building blocks of Tennessee's collective economic future. If cities and counties flourish economically, then the state flourishes economically. While the current proposal may seem like a minor tweak to the law, it will have far-reaching effects. Public Chapter 1101 has worked well. Please allow it to continue to do so. Thank you very much.
Thank you, Mr. Fleming. I know you all have a program sort of approach here, so rather than pepper you with questions at this moment, although you've inspired me to ask some, but I'll wait and let's go through the repertoire, if we may. Mayor Gordon. We almost could have ridden up here together, couldn't we?
Yes, sir, I believe that would be correct.
Good morning.
Good morning, Mr. Chairman and Commissioners. My name is David Gordon. I'm formerly a small-town horse and cow doctor, and I am now the mayor of Covington, Tennessee. Thank you for this opportunity to be here this morning and share some of our thoughts on these important matters. A number of bills seeking to amend Public Chapter 1101 were referred to TACIR for incorporation in your report to the General Assembly. We have analyzed each of these bills and prepared written comments which we will provide for your review. However, out of respect for your time and recognizing the task before you today and over the next few months, I will limit my remarks to the current moratorium and proposed referendum, as their effects are essentially the same. Before I get to the substance of my remarks, I want to mention that questions have arisen as a result of the lack of clarity in the language of the moratorium itself. For example, one of the key components of the moratorium is its prohibition on annexation of any land used primarily for residential or agricultural purposes. Does this mean its designated use as delineated in the zoning, or its active use? What constitutes a primary use? Does this use have to exist over the entirety of the territory to be annexed, or is it sufficient that it exists on any portion of the territory to be annexed? Another example is found in the phrasing associated with the potential for exception afforded an annexation ordinance that was formally initiated prior to April 15, 2013. There are many steps and stages relating to the process of annexation. Which of these steps or stages constitutes formal initiation of an ordinance? These questions, I believe, merit attention, and we will provide these and other questions regarding the language of the moratorium to the Commission and request that they be considered for the inclusion in your review. Now I will address the more troubling aspects of promoting the policy of substituting the moratorium or referendum for the law that governed growth in the state for nearly 15 years. Mr. Fleming mentioned the impact of the flexibility afforded under Public Chapter 1101, as well as the local prerogative granted in the law. The combination of flexibility and local prerogative found in the law produced one of its greatest benefits: certainty. Certainty for counties, certainty for municipalities, and certainty for all the residents of the county, whether they reside in a municipality or in the unincorporated areas. This certainty has enabled local governments across the state to be proactive in their approach to growth. As a result, the flawed practices of the past have largely been left in the past, just as the authors and supporters of 1101 intended. And we have successfully created an environment that promotes and facilitates responsible, planned, and intentional growth, or what the law's authors described as orderly growth. It is an irrefutable fact that most efficient and cost-effective time to address growth is before it occurs. It is far more efficient and less costly to ensure the location of proper facilities for water, sewer, stormwater, and fire protection before land is fully developed. Similarly, it is more efficient and less costly to plan and finance streets and other necessary infrastructure in advance of development. It is also more efficient and less costly to establish basic life-saving building and development standards that promote a safe and healthy environment for property owners and residents before all the homes and businesses have been built. And it is more efficient and less costly to plan for the delivery of services in advance of development. For these reasons, municipalities annex territory within their urban growth boundary, consistent with the intent of the law and the plan that has been duly adopted by the local governing bodies of each county. And it is for these reasons that municipalities have invested in capital projects, facilities, streets, and other infrastructure, and provided services to those areas where they are afforded the autonomy to annex under the growth plan. And I would add at this point that the four largest towns, cities in the county of Tipton all provide services outside their corporate limits. Again, this manifestation of responsible planning and orderly growth is directly attributable to the certainty that allows a proactive approach to growth. A certainty that is due solely to the credibility and existence of a duly adopted local plan and the autonomy granted a municipality to act on that plan within the processes and rules spelled out in the law. However, if the General Assembly were to choose to permanently substitute the current moratorium or any other referendum proposals for the exclusive authority granted municipalities under PC 1101, then the benefits of orderly growth will be greatly diminished. Such a decision would also likely hasten a return to some of the very practices and circumstances the law was enacted to preclude. A referendum, even a qualified or limited referendum, would negate the autonomy afforded under the law. It would also fundamentally alter the processes and rules established under the law, effectively nullifying county growth plans in spirit, if not in form and substance. Consequently, municipal limits would be largely determined by the unwilling property owners rather than a reasoned approach to development. The certainty that has empowered a proactive approach to growth would be eliminated, leaving counties, municipalities, and their residents shrouded in uncertainty. It is far less likely that growth would be the byproduct of a responsible, planned, and intentional effort. Rather, any growth would likely resemble the unregulated growth most often associated with sprawl. There would be no assurance that development was occurring in the most efficient and least costly manner. A municipality would have to question the wisdom of continuing to partner with county and or the state on capital projects outside their existing incorporated border. Would those four largest cities, towns in Tipton County provide any services outside of their corporate limits in the future? It would create the possibility that a municipality's facilities could remain stranded indefinitely in an area that could no longer be incorporated, or that those facilities already in place would be in a location from which it no longer made sense to serve those who are included or who wish to be included within the incorporated limits. The likelihood of this occurring will inevitably lead many municipalities to end the practice of providing utilities and services beyond their city limits. What is to happen to those areas where the municipality elects not to provide services and neither the county nor any other governmental or private provider is able to fill the void? What is to happen when substandard development occurs and harms the character of the area, driving down property values? What is to happen when property owners find themselves with failing septic systems? What is to happen when there is a desire for fire or police protection beyond that currently afforded in their area? Remember, the city taxpayers will have a choice too. In an area of uncertainty in which infrastructure is established and services provided after development has occurred, there is no assurance that annexation will be an option or that either the property owners or the city residents will be willing to incur the associated costs. And as the justification for the loss of many benefits derived under the law, advocates for this change counter that a referendum means that the people get to decide whether their land is annexed rather than an elected body. Thus, if an individual wants to be annexed, then they may be annexed. Conversely, if an owner does not want their property to be annexed, then it will not be annexed. Sounds appealing, but is it accurate? The supporters of the current moratorium seem to share a common belief that anyone that requests to be annexed by a municipality will be granted that opportunity. This is simply not the case. First, the law requires that any territory to be annexed must touch the city limits. In addition, the courts have taken a very disapproving view of the utilization of strip, corridor, or finger annexations because of their effect on the physical border of a municipality, as well as their association with the practice of cherry picking only the most attractive areas and the existence of a disparate level of services available to property owners within close proximity. And I think we saw yesterday exhibits showing us that the practice of bringing in only those who wanted to be annexed and not those who did not want to be annexed produced corridors, donut holes, and strip annexations. Consider two likely hypotheticals, if you would. First, assume a property owner is requesting to be annexed for the purposes of developing land for residential or commercial activity. Second, assume a group of property owners residing in a subdivision decide they want to be annexed in order to receive sewer and city services. Now let's further assume that the properties presented in the hypotheticals are not contiguous to the city limits. Under each scenario, the city and requesting properties would likely be confronted by some very difficult circumstances and facts under the current moratorium should the owners of the property occupying the space between the requesting owners and the city limits not want to be annexed. Absent exclusive authority to annex within its urban growth boundary, the city would have no means of reaching the requesting properties other than a highly suspect corridor annexation. Even if the city were willing to risk inviting a likely legal challenge, the issues associated with bypassing properties and the obstacles it would present with respect to providing police and fire protection and the viability of extending utilities and maintaining streets and other infrastructure would remain. As such, annexation would be unlikely. Therefore, the mere fact that owners opposed to annexation are in closer proximity to the city limits than those requesting annexation would preclude the annexation. This would not be the case under Public Chapter 1101, as the city could annex all of the properties by ordinance. The same is true with respect to a referendum in which the owners are unwilling to be annexed are equal or greater in number than those desiring to be annexed. In this case, the owners in opposition would prevent the owners requesting annexation from realizing their desires. As these hypotheticals illustrate, neither the moratorium nor referendum is the cure-all that it is perceived to be. Whether you are operating under PC 1101 with its exclusive authority to annex or by ordinance or under the moratorium or referendum, someone loses. Under city-initiated annexation by ordinance, it is the unwilling owners. Under the moratorium or the referendum, the willing property owners are the losers. Thus, the choice between city-initiated annexation and the moratorium or referendum constitutes a determination as to who wins and who loses. With a city-initiated annexation, there are the restrictions of the law and its process, including the county growth plan, public meetings, and the requirement that an annexation be approved by a vote of elected representatives in a public session. And there is the opportunity to challenge the validity of the annexation in court. Therefore, city-initiated annexations under 1101 at least offer the prospect that the annexation is consistent with the interest of the community as a whole. While under the moratorium or referendum, annexations will be determined solely by individuals' preferences and self-interest. Many of the supporters of the current moratorium also seem to share a common belief that a municipality is free to annex any territory other than that which is used primarily for residential or agricultural purposes by ordinance. Again, this belief presumes that all such properties are either contiguous to the city limits or that there are not any properties that are being utilized for residential or agricultural purposes between the property to be annexed and the city limits. If the property to be annexed were not contiguous and there are no properties being utilized for residential or agricultural purposes occupying the space between it and the city, then that annexation could only be executed by referendum. Another issue to consider regarding the moratorium or referendum is the management of the pockets of unincorporated areas that are either completely or predominantly within the incorporated limits, commonly referred to as donut holes. Similar to corridor annexation, donut holes create confusion and inequity, add to the cost of providing services, and pose challenges for emergency responders. Many of the donut holes that existed prior to enactment of Public Chapter 1101 have been closed. Moreover, very few donut holes have been created following enactment. The few that have been created are often the result of a municipality's attempt to either exclude or work around those owners that oppose proposed annexations. Under PC 1101, a city has the assurance that when it becomes necessary or is prudent, it may annex these areas and close the donut hole. However, with a moratorium or referendum, it is very likely that most of these donut holes will remain indefinitely. I would encourage all of us to try to identify the problems that exist with Public Chapter 1101 and seek solutions for those problems. Mr. Chairman, this concludes my remarks. Thank you for your consideration.
Thank you very much, Mayor Gordon, and we'd like both you and Mr. Fleming and all the others to give us copies of your remarks, because you put a lot of effort into those, and it would be helpful for us to have those for the record so we can review them and continue to consider excellent points. And again, I know you're in the middle of a program here, and I don't want to interfere, but I know we've got members that have lots of questions and comments in response to your fine points. Thank you. Mayor Bickers?
Thank you, Chairman.
You? Here we go.
Thank you, Chairman Norris. I'm Tom Bickers. I'm mayor of the town of Louisville, Tennessee. For purposes of geographical reference, Louisville is located on the northern boundary of Blount County. We are neighbors of Knoxville and the city of Farragut across the Tennessee River to the north, and we're bounded on the east by the Knoxville Airport and the wonderful city of Alcoa. So perhaps that gives you some reference. I also suspect we hold the honor of being the newest town here today. We were incorporated in 1991, and we've seen our population grow from a few hundred in the past 22 years to more than 4,000. So as we've had to address many of the issues that come with rapid growth and being in an area by proximity and hopefully by the way we govern that people want to move and live and reside. I'm also probably hold the honor of being the youngest mayor, or newest mayor here, because I was first elected to elective office in November 2010. So I'm new at this. And so if I step on any toes, please take it out on me and not the other members of the panel or TML. So bear with me as we work through this. In addition to mayor, I also bring some experience to the podium because for almost 25 years I've been a partner in the Knoxville law firm of Payne, Tarwater, and Bickers, where I've had the privilege of representing individuals who have been involved in annexations. And so I've not only seen and been involved in annexations from the role as a mayor undertaking them and seeing them through, but I've represented individuals who have been dealing with it, and acting in opposition to cities and municipalities trying to annex them in. So I have some understanding of both sides of this, I like to believe. I've also practiced law long enough that I was involved in litigation before 1101, when we dealt with tiny towns and all of the morass that was Tennessee annexation law. And I would suggest to you that even if we have some problems in 1101, it's much, much better than what we had before it was enacted. I'm going to talk to you primarily this morning about what some of the arguments are against annexation by ordinance. But I first want to mention, and would hope that the legislature doesn't lose sight of the diversity among Tennessee's many different towns and cities. We have different forms of government. We have different ways that we govern. We have different missions and services that we provide, and we have different ways that we raise the income or the revenue that we need to carry out our missions. I think it would be a mistake to assume that one size fits all, because Tennessee has recognized that diversity as a good thing. That's why we have cities and towns and counties and not metropolitan governments all across this state. And I think it would be a mistake if we forget that and lose sight of that diversity. That diversity also means there are different reasons why the different cities and towns and municipalities would engage in annexation. We'll discuss that a little further, but again, I think it would be a mistake to assume that one size fits all and all cities and towns should be put into the same box, because that's simply not how the world is. But what were some of the arguments that were raised? We've gone back and reviewed the legislative history, not only of the bill that was enacted with the moratorium, but with regard to many of the other numerous bills impacting annexation by ordinance this year. And really, if you look at it, it really boils down to 6 primary arguments as to why annexation by ordinance is supposedly a bad thing. It was argued that such annexations are an unlawful taking. Okay, but if you take somebody's property without giving them the right to vote, that constitutes an unlawful taking. There are arguments that it's unlawful because people should have a due process right to vote on whether or not they want to be in a town. And even if it isn't a legal right to do that, as a matter of public policy, we should give anybody who's subject to potential annexation a right to vote. We should make sure we ensure representation. It was argued that annexation by ordinance violates some certain unenumerated property rights. Okay, it was argued that annexations are simply a means by towns and cities to grab money. It's all about the money. And it was argued that cities and towns are not providing the services that they said they would in the plan of services, so we shouldn't let them annex by ordinance. And I heard, I guess, if once several hundred times, Tennessee is one of 3 states that allow annexation by ordinance. That seemed to be one of the mantras coming off out of Nashville this spring. So let me address each of these briefly. As you know, the suggestion that annexation by ordinance constitutes an unlawful taking, and I apologize if I put my lawyer hat on, but that's simply not a correct statement of the law. As the Tennessee Attorney General recently recognized in a formal opinion on July 25 of this year, that issue has been before the Tennessee Supreme Court and it's been rejected. Okay, when annexation doesn't change anyone's property rights, okay, they still own the property. Title doesn't change. So at most, annexation could impact your potential way you use your property, just like zoning could. It also may subject you to taxation or fees, some monetary impact of that. And the Supreme Court has said that's not a taking. And that makes sense, because if that was a taking, then virtually much of what we do, either as state or local legislative bodies, would constitute a taking, because we enact countless pieces of legislation every year that impact land use and that may result in some financial impact. Okay, and so that can't be. We could not have government as we know it if that constitutes a unlawful taking. And that's why the Tennessee Supreme Court rejected that argument and simply stated that is not a correct statement of the law. What about the lack of notice issue and lack of representation? Well, likewise, that has also been before the Tennessee Supreme Court as well as the United States Supreme Court. And I apologize for having my lawyer hat on, but these are the legal arguments that were made. And as the court recognized, there simply is no due process right to be able to vote on whether you want to be annexed. Okay, that legal right does not exist. Our courts who tell us where these rights are have said they don't exist. And in fact, in Tennessee, there is representation under 1101. And I want to spend just a minute identifying how that works. Before under 1101, the counties put together an urban growth boundary. Okay, and there was participation by representatives of the counties as well as the cities. Okay, and as a result of that, the areas of which were someone who knew, but he or she became aware that their property was subject to annexation sometime within the next 15 years. It may not happen, but they were on notice that that was a possibility. Okay, that plan had to be approved by the legislative body of the county. And so that when the county approved that, that body represented every person in the county. Those people had representation. If they didn't like it, they even had avenues in court. So to say there is no current representation of the development of the urban growth boundaries is simply not correct. I'm not going to suggest to you that everybody knows whether they're in an urban growth boundary or not, because reality is they don't. No more than they know what the zoning is for where they live. They figure that out when they want to do something, they can't do it. The other ways that there are notice is, there is at least one public hearing before the annexation. Many towns, municipalities, and we've done that in the past in Louisville, would also hold informational meetings and say, here's what's going to happen. Come to town hall, to ask us your questions. We will do our best to answer them. We want you to know what's going to happen. People, in many of the instances, people know what's going on. And of course, there is under 1101 a judicial remedy. If you feel like you've been particularly aggrieved and the burdens haven't been established, you can always go to court. And finally, the new people annexed have the ultimate remedy. All right, if they don't like what I've done, if they're mad about the annexations, they can vote against me. And I'm not sure how much greater power they have than to say, we oppose that, you shouldn't have done it, so we're not going to vote for you should I choose to run for re-election. So there are also some policy issues that are implicated when we say we're going to require a referendum prior to an annexation. For example, who does the right belong to? Does it belong to the property owner? Well, if the property owner doesn't live there, well, if the property owner is not registered in your town or in your county, okay, even in your state, well, does it belong to the residents? Well, what property rights do the residents have if they're simply renting a house or an apartment? Okay, who should that vote go to? And should it be a vote by individual or a vote by parcel? We saw what happens when we said we're going to do property owners. If you paid attention to what went on in Pigeon Forge recently, when suddenly we had, hundreds of people became new owners of properties so they could vote in an election, and then amazingly after the election, they all sold their interest back. Right? Is that what we want to create by saying we're going to tie voting to property rights? Okay. And do we say you get one vote? Or, so a widow on a farm gets one vote, but a family with 10 voters living with grandma gets 10? I mean, there are serious issues if you want to go that route and say we're going to say as a policy you have to vote. These are all serious things that have to be addressed. But one of the other, and I'm not sure I've heard the explanation about what makes annexation special. I mean, our legislative bodies enact legislation, numerous pieces of legislative acts, but the state and local level every year. Okay, many of them impact property. Many of them impact our pocketbook. Okay, so why are we going to carve out an exception and say, well, for annexation you get to vote, but these others you don't? Sure, we're not going to become California where you vote on everything. But it's one of the other problems with eliminating annexations, the ordinance was touched on by Mayor Gordon, and I will share with you, if I can, some of our experience in our town. We were, under our original charter, limited to annexations by request only. And what we saw over the first decade and a half of our town's growth was the development of borders that looked more gerrymandered than any congressional district, and numerous donut holes, okay? Because you might have one or two who said, I don't want to be in town, for whatever reason. Some people just don't like to join anything, right? And so they would be surrounded. And so we had pockets within the town where we would have a street where we might have half the houses on each side in and half on the other side in, and the rest out. Well, imagine how that impacts your ability to provide public services. And that's a direct result of having annexations only at the request. Okay, and that's what we'll go to, in essence, in many ways. Okay, we had donut holes where we didn't have a property owner living there. And so if I wanted to close it by referendum, I had nobody that could vote. I mean, it was going to be a donut hole or an enclave in perpetuity because nobody's there, okay? And so surely it can't be sound public policy for this state to encourage the development of donut holes or enclaves, okay? And to make it difficult, if not impossible, to eliminate them. I would suggest it ought to be the public policy of the state to encourage towns, if not mandate, that they close donut holes instead of engaging in legislation where they could be created. I want to also address the property rights issue because we heard that a lot. You know, this is about property rights. Okay, a man or woman owns property ought to have a right to say what happens to that property. I never heard, putting my lawyer hat on, I never heard them enumerate where that so-called property right comes from. You know, they didn't identify a constitutional provision, either the state or the federal constitution. They just talked about property rights in much the same way that people that oppose zoning say it's my property, by golly. Nobody's going to tell me how I'm going to do, what I'm going to do with it, okay? And on face value, that seems appealing, right? If you own a piece of property, you ought to have the ability to dictate as much as you can what you do with it and how you use it. This is America, after all, okay? But when you drill down, I think it's important to understand that many times we're not just talking about the property rights of the people on the outside of municipality. We're talking about the property rights of those inside a municipality as well. And if you'll give me the indulgence, I'll share with you a little bit about the town of Louisville. As I said, we're a waterfront community. We have 3 significant watersheds that flow through our town into the Tennessee River, the Fort Loudon Reservoir. Countless of our property owners and our residents own property that touches the lake or that watershed. The quality of water in that water is of paramount importance to us. Okay, it's who we are. We also understand that everybody upstream from us is our neighbor. And just like the people in Cott County figured that out about Champion upstream. Okay? And we have undertaken annexations to the extent of our growth boundaries for the purpose of including as much of that watershed into the town as we could. Because we understood that there could be activity in that watershed on the boundary of the town, even within our urban growth boundary, that could cause significant diminution in the property values of our residents. Right? If somebody makes a mess of the water, we could have millions, if not tens of millions of dollars in diminution of property values. So surely it should be a proper exercise of government authority for us to reach out, and while I understand that we are impacting those individual property owners, we are doing so to protect and preserve the property rights of the many in our town. Okay? I understand that one of government's purposes should be to protect some individual rights. But government authority also ought to be exercised to protect the many from the potential injurious actions of the few. And one of the ways we can do that is through annexation. Okay? And if we're limited by referendum, that limits our ability to do that. So, I have yet to hear anybody explain to me why the property rights of someone on the outskirts of Louisville are more substance and more value than the collective property rights of all of our homeowners and property owners inside the town. And so property rights isn't a simple issue. You can't lose fact that there are more than just the non-resident property owners at issue. What about this argument that annexations are simply a money grab? Heard that a lot. Even heard terms like Ponzi schemes and other things, that the only reason you annex is to go out and get money to pay your bills. Basically, cities aren't physically responsible, so They have to go out and they have to bring in new property tax dollars. Well, that's one of the situations where one hat doesn't fit all. Because I'll give you an example. We don't have property tax in Louisville. Okay? We've chosen, under our form of government, right, we've chosen to provide the revenue through another means. Right? We don't think public policy supports a property tax. And so when we have annexed people in, they've not had any increased tax burden. In fact, their burden of ownership goes down because we assume fire protection and many other services that they're currently paying for. So there is not one person who has suffered one loss, 1 cent of monetary loss by annexation by Louisville. Okay? And so when we hear how it's all about the money, it's not. Okay? That's attempting to put all of us into a square hole. And some of us are round. Some of us are more round than others. But some of our cities are round. Okay? And so you have to, I think we have to get away from this idea that cities are bad. Okay? They don't care about anything but money, because that's simply not true. There are many of our cities that engage in annexations not because of the money, but because we want to improve our community. Right? We want to make the community better. Okay? So please don't lump us all into that category. But even for those that do have a property tax, if you go back and you look at the data, right, about what those cities are spending, okay, generally they're spending more, at least in the short term and the near term, than they're bringing in. All right, it's not about the money for them. Okay, and if you do anything, I would encourage you to look at the data. Let's base decisions on data and not anecdotes or conjecture. So that sort of leads in, and I'm just about finished, the argument that cities don't provide services. Again, I will suggest that's a general overstatement. In our town, I assure you within 6 months everybody's getting every service the town provides. We've never had the argument that we weren't. Okay, and I know that there may be instances where it takes longer in some towns and some municipalities, and there may be issues where it's not being done. Okay, but this is where I would encourage you to do your research. Okay, let's identify what the problem is. Okay, where the problem is. Okay, let's not base decisions on conjecture. Okay, on anecdote. Okay, I'm still naive enough to believe that before government acts, it should have a justification before it enacts new or changes legislation. Okay, and that justification should be based on solid information and data, and not some anecdote about, well, here's what happened in Blount County, right? Or here's what happened in here. Okay, let's do our research. You know, let's identify what the problem is. Okay, okay. You know, Tennessee may be one of only 3 states, right? But let's not do what we do because somebody else does it. Let's do it because it's the right thing to do. Okay? I'd hate to think we decide whether to have an income tax on what other states did, because we've decided in Tennessee that's not who we are. Okay? So let's focus on the problems here. Okay? Let's identify what the cause is. Okay? And then and I'm still naive enough to suggest that when we identify the problem and the cause, we should only do that government action that's necessary to solve the problem. Right? Why should we do more? Okay, why do we throw the baby out with the bathwater? Right? We shouldn't take a sledgehammer to kill a gnat. And with all respect, it appears that's what we're trying to do with this legislation. Okay? Instead of using an appropriate means to deal with the problem and perhaps the bad actors, we're taking the sledgehammer to all of our towns and cities. And I would urge you not to do that. Thank you.
Thank you, Mayor. Of course, just so the record's clear for those looking in, we're looking at Chapter 1101 in toto. I know you were focusing in your remarks on the specific issue of annexation by referendum, and if that were all that were under consideration, I hear you, but it's broader than that. Mr. Hammond, be nice to have you at the podium. I see you here all the time. Don't get to hear from you much.
It takes a long time to work your way up to podium time. And I appreciate Mayor Bicker's willing to throw himself onto the sword, that if he inadvertently steps on someone's toes, that you hold him accountable. And I'd like to ask the same thing, if I step on someone's toes, if you would hold him accountable. My name is Bill Hammond. I'm the Assistant City Manager for the City of Alcoa. I've had the good fortune to work in municipal government in Tennessee for 35 years. I've got a couple of different hats on today. I'm currently the president of the Tennessee City Management Association. In that regard, I'm serving on the Tennessee Municipal League Board of Directors. I'm a contract employee for the University of Tennessee and carry a basic economic development course across the state, which affords me to get to see different cities and counties and situations across the state that give me a fairly broad perspective on not only my own circumstances in Alcoa, Tennessee, but what's happening in the 3 Grand Divisions. I appreciate the opportunity today to be here and share some information with you relative to Chairman Norris's comments. I'm going to talk about 4 or 5 bullet points on the broader aspects of maybe tweaking some 1101 issues that I'd like for you to consider, and then I'd like to go into have another component to where I specifically reinforce what we've already talked about in the past, where there's a lot of diversity in the state, and show you some specific examples of how that impacts the way we do our business in the city of Alcoa. So first off, dealing with the urban growth boundaries. Over the years, after the 1101 legislation was set up, we would have individuals that would be on a boundary that might have a family farm, might sell a family farm, for different reasons might want to divide a piece of property. And so instead of having a piece of property that either straddles a border or maybe solely outside of the urban growth boundary, because of changes in ownership of the property, those individuals may want to come back and petition the city to say, we'd like to be included in the urban growth boundary, or we'd like for you to annex us. And right now we would have to go through the process of petitioning for a referendum to have that occur, or to reconvene the operating committee. Both are expensive, both are time consuming. We would like for the TACIR to consider as an alternative to that, and tweaking the 1101 processes, that we develop a streamlined process that allows the property owners to ask for consent to be included in an urban growth boundary if it doesn't impact any other surrounding municipality and doesn't get anybody else's urban growth boundary, if it's just a city-county issue, so that we avoid the expense and time it takes to go through that process of the petition for the referendum or the convening of the coordinating committee. That would be one item. Another thing that happens across the state, we've got several cities that straddle county lines, and so they're in 2 different counties or more. They offer services in 2 different counties or more, and in a couple of cases we have situations where a city's in one county, and in that county they have the majority of their population growth, and they have property that they own in another county, and right now the requirement is if you don't have 7% of the population in that other county, it restricts your ability to annex properties or have properties added to your urban growth boundary that you might very well own. And in our case in East Tennessee, Morristown is an example of that. And so what we'd like is some consideration that in situations where you've got a municipality that actually solely owns fee simple property in another county and doesn't meet the 7% requirement, that they're able to bring that in to the city and not landlock that piece of property. Another thing that we've seen across the state is that in some situations you have cities and urban growth boundaries that are multiple contiguous to other places. For instance, in the city of Alcoa, the city of Alcoa city limits touch the city of Knoxville city limits, the city of Maryville city limits, the city of Rockford city limits, and the city of Louisville city limits. And then we have the counties growth boundaries or outside of those areas. In the case, I'll just use Alcoa and Maryville. In the case of Alcoa and Maryville, if we have, again, a property owner that has a piece of property like a large farm that's half in Alcoa, half in Maryville, or some combination thereof, we'd like to see an administrative process to where the two cities could just resolve that. Again, if it doesn't impact another existing municipality, and if it's just the two cities dealing with their different boundaries, so that we can square those up. An example of that is in the core area of both cities. Last month, we had a piece of property that a property owner was trying to develop, and it literally was straddled, half in Alcoa, half in Maryville, and it didn't line up with property lines, it didn't line up with street lines, it didn't line up with utility alignments. And so we de-annexed half of it, Maryville annexed half of it, they de-annexed half of theirs, we annexed half of theirs, and so we resolved that ourselves internally. We'd like the same flexibility to look at doing that with urban growth boundaries as well. Under planning, one of the things that's really critical about preparing property for development is that if you wait for development to occur and then trying to accommodate the development, you're behind the eight ball. That goes for street, utilities, anything where you might have densities that would put people that have capacities higher than the capacity of the utilities to support it. Street congestion, utility, water, sewer that can't support development. And so one of the key elements about density issues inside the city, outside the city, is the ability for the cities to have some influence on the zoning of property. As we go along and install infrastructure outside the city, it's really helpful to us to know whether we should be putting 12-inch transmission lines in, water lines in, or 6-inch lines in, because based on the zoning of the property, you can calculate the density and you can calculate what the volumes and the pressures are going to be needed to support that. And so it's critically important over time that not only do municipalities have the planning controls and the urban growth boundaries, but they also have the zoning controls, because the zoning controls really impact the densities and give you the ability to plan for those future improvements. Another thing that's critically important relative to the development of areas outside the existing municipal city limits and the urban growth boundaries is the provision of utilities by both public and private utilities. When you have an area that you have planning jurisdiction in, and someone comes in to develop a piece of it, and they want to put 2-inch water lines in because that does service the domestic needs of that area, there's a volunteer fire department, so they don't really have any control over, they can't require fire hydrants and that kind of thing. Then when you move in and that property either is more densely developed or annexed, and you've got issues of providing water volumes and water pressures, if you've got a matrix of 2-inch water lines, it's incredibly expensive to go back in and put a minimum of 6-inch water lines. You have to have a minimum 6-inch water line to support fire hydrants. So what we'd like to see is that in areas that are in UGBs and you've got planning authority and zoning authority, that we also require the requisite stormwater management type reviews and the underground utilities and the size of the utilities, so that nothing has to be ripped up, taken out, or abandoned or anything like that as that property begins to develop and becomes more dense. I say all that to say that in the city of Alcoa, we're a little bit unique, which plays to the point that one size doesn't fit all. And I want to run down just very quickly for you. I won't beat a dead horse over some of the issues we've already covered, but we have extensive utilities outside the city limits. I have more sewer, water, and electric customers individually each outside the city limits than I have inside the city limits. And the reason we've done that is over time, in East Tennessee, we're a very hilly, mountainous area, and so you can't let water systems rely on pressure, head pressure, and sewer systems rely on gravity flow. So we have water pump stations, sewer lift stations, I have water tanks, water towers, I have huge interceptor sewer lines, I have transmission water lines. all outside the city limits in anticipation of growing into those areas and annexing them. And what happens is, in areas where I have sewer, water, and electricity already outside the city limits, and we feel like the timing is such that we ought to look at annexing those areas, if we're held to a referendum, I end up with a stranded investment, essentially, because I've got capital infrastructure I've already bought and paid for and done bonded indebtedness on, and I'm running the debt service on it. It's in the ground. And if I have a referendum and somebody says, well, I already have all the services. I have sewer, water, and electricity. Why do I want to be inside the city? It's kind of a gun in my head, and I have a stranded investment to where I may or may not be able to recoup that as a business cost. So it's important to us that the utilities are considered as we move forward to look at this and leave that option available when you start talking about. I don't think you can just wholesale say, with deference to the sponsor, that referendum's a bad thing. Annexation by ordinance is a bad thing. Everything's got to be referendum. In certain cases, I think it's just the other way around. Without the annexation by ordinance, it really creates a lot of problems for us that others have enumerated before me. And in talking about the utilities specifically, we have an electric system that has over 1,000 miles of conductor line, and that means from Alcoa, Tennessee, I have enough conductor to run to Washington, D.C. and back. In East Tennessee, we're rugged and we're rural, so it's very difficult to maintain those lines outside the cities. I'm negotiating right now to buy a 7-acre site 10 miles outside the city limits for an electric substation that's going to benefit primarily county residents. In the last 5 years, we've put over $10 million worth into water tanks and water towers outside the city limits that gives pressure, again, to county residents, county customers. So we're joined at the hip with our colleagues at the county. We're very fortunate, as some of those indicated yesterday, that we have 6 cities in the county in Blount County. We all get together really well. We work well with the county. We share a lot of things. We have a lot of memorandums of understanding with each other, mutual aid agreements with each other. We share public services when we need to, and so we're in a fortunate situation that we have a very collaborative process in our situation that makes us work really well together. The city of Alcoa is a city of about 8,500 people. We run the Blount County landfill for a county of about 130,000 people. And so that's unique in itself. It's one of the most high-tech things we have in the county. Landfill operations are extremely high-tech, very expensive. We mine the landfill, and we generate methane, and we produce electricity off of our methane and put back in the TVA grid. So we generate enough electricity that pays for the capital costs for the methane plant, plus we put energy back in the grid, plus we amortize the debt service on the plant. So I say that to say that a lot of cities do a tremendous amount of activities and things that are to the direct benefit of county residents, and we enjoy doing that. We're happy to do that. We get regionalism and we get cooperation. One of the things that we just opened up 2 years ago is we had the city of Alcoa, the city of Maryville, Blount County, and Knox County. We jointly developed a 500-acre research and development park. And we're all 25% owners. Knox County put $5 million into an industrial park, research park, that's solely inside the city limits of the city of Alcoa. So not only do we get along well and work with Blount County, we work with our surrounding counties in Knox County, and we try, where one of us does well, we all do well. And so we feel like that on this whole issue of 1101, the growth management issues, smart growth issues, annexation by ordinance, by referendum, I think we need to have as broad a toolkit as possible to make us as flexible as we can, so that as we move forward, when we have situations and opportunities, that we can take advantage of those, and it doesn't materially retard the development of a particular area, because we're hamstrung by not being able to do something we've been able to do in the past very successfully. Before 1101, we had fairly significant growth and development. After 1101, we've kind of pulled back a little bit on our extension of trunk sewer lines and transmission lines outside the city limits, and that's because we're just tentative about being able to have that money and take it out there and lay it in the ground, and then all of a sudden not be able to recoup our investment on it. So Again, we're very fortunate, we feel like, to have the relationship we do with our county. It's worked really well with the annexations by ordinance we've done with the county, and so if there's anything else that we can share or supply, I'd be happy to do that.
Thank you, Mr. Hammond. Thank you very much. We'll open it up to questions at this point. I think Mr. Wilbur, I'm sorry, Mayor, you want to close? I apologize. Glad you were looking at me intently.
Yes, thank you, Mr. Chairman. I will do some closing remarks and kind of tie some things other presenters have done together and give us some overall views of some thoughts that we do have. Again, Mr. Chairman, Commissioners, annexation is an emotional issue invoking strong feelings. This is not new. It has always been this way. And the notion of referendum is not a new development. In fact, referendum has been considered several times in the past, including during the review process that led to the enactment of Public Chapter 1101. And more recently, legislation has been introduced and debated in the years that followed enactment of Public Chapter 1101. Like those efforts of the past, these bills were also rejected. Perhaps we were predestined to have this discussion. A review of history of annexation tendency reveals that cycle patterns with annexation studies and legislation occurring roughly every 20 years. So perhaps this is just a function of the natural order of the universe. We come together to repeat many of the same discussions that have taken place over the years. Whatever the reason, we are here again discussing a referendum. So what is different this time? What has changed that suggests these discussions should produce a different outcome than all the prior discussions? Something must be different. We are, after all, under a moratorium. Sure, there must be some strong, substantial evidence of serious flaws in the current law that have led to widespread abuse and resulted in significant harm to the state and its residents. Well, under Public Chapter 1101, cities and counties are no longer living under the state of constant strife. The seemingly endless parade of lawsuits have ceased. Counties have greater assurances and predictability regarding the effects of annexation on their ability to fund schools and meet other demands on revenues. Court annexations have all come to end. There's greater continuity and regularity in city limits than ever before, and elements of sprawl are no longer pervasive. Donut holes and disparate levels of services are far less common. The law has provided predictability to identify areas where growth will occur, the freedom to expand infrastructure in unincorporated areas where none exists, particularly water and sewer, and the flexibility to manage and coordinate delivery of services more effectively and less expensively than any other time. The certainty afforded under the law has greatly aided allowing cities to facilitate private investment and commercial industrial expansion, thus giving the state a leg up on highly competitive, quick-paced agenda where timing is everything. Our state's population grew by 656,822, or 11.5% from 2000 to 2010. The increase in population of the state's municipalities accounting for about 67% of the total increase over the decade. According to the Census Bureau, the state added an additional 110,000 in population between the 2010 decennial census and 2012. Clearly, people continue to find our state an attractive place to live. This does not simply occur. Cities and counties work hard to manage this growth and provide our citizens a good quality of life. And it's not just the good quality of life issues that earn high marks. It seems there is a press release or newsletter from the governor, ECD, or the Chambers of Commerce at least once a month, hurling another noteworthy recognition of the state's pre-growth environment, its business climate, or its recruitment of industry. Moreover, the state has weathered 2 recessions since the enactment of Public Chapter 1101, managing to produce balanced budgets and avoid a state income tax. There is largely due to fiscal responsible policies, well as a healthy state sales tax base. The sales tax base is a direct reflection of the economic activity generated at the local level. These facts hardly suggest a cause for alarm. Again, I ask that transitions have occurred under the law that are so erroneous, pervasive, that they warrant responding to referendum differently this time. There is no issue regarding any taking of land. There's no sanctioning of taxation without representation on the law. The law does not constitute a violation of anyone's rights. The plain truth is there is no argument on the basis of law. Yet these arguments continue, accounting to a little more than rhetorical diversions intended to incite emotions and create divisions. We're told that a referendum is needed to give residents a voice. This presumes that today residents have no voice in the process. There are notice requirements, public meetings are required, there are avenues to challenge the validity of annexations. Public hearings are held to ensure plans of services and completed as promised. When plans of services are implemented, then the law provides access to the remedy. I know on the public hearings, we went through the 1101. We're a city in 2 counties, and we did actually work with another city to move its line and to increase our growth there. There was a minimum. We had 6 public hearings that were required, and plus we had a couple of others. So I know from a public experience that the public hearings do take place. And let us not forget that no resident of this state, whether they reside within the incorporated areas of the city or the unincorporated areas of a county, is without elected representation. Each of the state's 95 county commissions, acting in their capacity as elected representatives of county residents, adopted a growth plan. These commissions adopted these plans with full knowledge that their action carried the force of law and with the full understanding that any properties located within a city's urban growth boundary were subject to annexation by ordinance. Having a voice is different than having a direct vote. If representative democracy is no longer a valid means of governance at the local level, then it should not be invalid at the state or federal level. If we're going to throw out the notion of representative democracy with respect to local ordinances affecting property, then why not also any state laws relating to property? Why stop with laws pertaining to property? Again, I ask that events have transpired since the enactment of Public Chapter 109 that so clearly point to the need to respond to the question of referendum differently this time. Even the proponents of referendum have conceded that 1101 is good law. They suggest they don't want to change the law, but only want to make a simple modification to perfect an otherwise good law. I would confess that this is clever positioning and even maybe good politics, but I would hasten to add that it is dead wrong. Substituting a requirement for referendum for municipalities' exclusive authority to annex by ordinance is hardly a simple modification. I would submit that if it were truly a simple modification, then the proponents would not be so insistent there would be no need for us to be here before you today. Implementation of a referendum would not occur in a vacuum, absent by consequence, as some have suggested. Rather, it would fundamentally alter the current practices and processes and the short-circuit validity of all gains achieved under law. Referendum would eliminate certainty and also remove predictability. Consequently, growth will not be planned and intentionally. Rather, municipalities will be restricted to reacting to development that has hardly occurred, resulting in more limited and sporadic growth patterns. Our ability to recruit private investment and create jobs will be harmed because the guarantee of incorporation that is currently offered in businesses looking to locate an office or facility will be lost under a referendum. Some cities, under the threat of the loss of certainty provided by the local prerogative, are also reassessing their willingness to partner with other local governments on capital improvements outside their incorporated areas. Others have terminated or are considering terminating their practices regarding installation infrastructure and facilities beyond their city limits. This is likely to become commonplace if a referendum is adopted. The combination of current moratorium and referendum, existing restrictions concerning continuality and corridor annexations mean that some property owners desiring to be within the city limits will be subject to preference of property owners that are in the closest proximity to the city limits. Even those willing property owners that are not landlocked would have no assurance of annexation, as it may not economically feasible to extend utilities or practically to bypass tracts of land to provide police, fire, and other services to a single property or small cluster of properties. In closing, I would ask one final thing. What horrible abuses have occurred that would lead to the state to do what it has been unwilling to do for 60 years, adopt a referendum requirement? What events have transpired that would lead the state to jeopardize many of the benefits that have been realized in achieving Public Chapter 1101? Even proponents of referendum have acknowledged that a great many cities are conducting annexations the right way. Instead, the critics of law point to the existence of a few bad actors that have contended are merely interested in grabbing land or revenue and fail to provide services in return for taxes. If so, then why punish based on the purported deeds of a few bad actors? Why not simply figure out how to best stop the best practices of few? Mr. Chairman, that concludes our remarks. Again, thank you for you and the Commission and the members for the attention for this opportunity. And let me also add thanks to all of the Commissioner staff for the work that has already been done and the effort I know will continue to be done this important issue.
Thank you very much, Mayor Wilbur. I appreciate that. And to your point, I'd say that's exactly what the Advisory Commission and perhaps the legislature is attempting to do. Not trying to punish anyone, but to see where there may be abuses, where there may be inefficiencies, where perhaps the statute promulgated under Public Chapter 1101 is not working as well as it could. And I'll remind the members of this commission and those tuning in that under Title VI, TACIR was charged with the responsibility to monitor and periodically report on progress under Chapter 1101. And before the legislative session that spawned some of the particular bills that you've referenced, Public Chapter 441 being one of them concerning annexation, this commission had determined it appropriate for us to include in our plan of work a review and an update of where we are under 1101, because we have these 20-year growth plans, and we found that we were approaching year 15, and by golly, nobody had gone back to do a reality check. So how we're doing. It happens to coincide nicely with Public Chapter 441 and these other pieces of legislation that are referenced here. But that's the overarching question, and surely the question about annexation by referendum looms large as we look at this. But to Mayor Wilbur's point, you know, what is it that prompts folks to focus on that in some cases? And I know we'll want to hear from Representative Carter, and there are others that will have questions. You all have covered a tremendous amount of very important considerations here, and you can see that one person's problem is somebody else's panacea. I keep trying to think of how to sort of summarize. We learned yesterday the difference between donut holes and islands. You know, one man's hole is somebody else's island. We talk about sprawl. You know, one town's sprawl is somebody else's Shangri-La. It just depends on, you know, where you stand depends on where you sit and that sort of thing. So we have a lot of issues to consider. You've talked about accountability. You've talked about efficiency. You've talked about certainty. And maybe to begin the conversation, what if we turned this around and looked at it from the other end of the tube and said, well, let's say you're all right, and it should be annexation by ordinance, and if you're doing your jobs the way you, meaning municipalities, the way the law was intended and everyone would hope, everyone will live happily ever after. Let's look at it the other way. What if they don't? Maybe they should have the right to de-annex by referendum. What if you split that baby? I'm just curious if you'd think about that paradigm shift instead of on the front end. What if the law allows you to do as you do now, and if you do a good job, somebody feels aggrieved by it, and they call a referendum on, well, we don't think the city's delivering as it should have. We think the city's abusing our rights, whether you agree that we have them or not, and therefore it's sort of like the recall. Mayor Bickers, you talked about if they don't like the job you're doing, they can vote you out. Well, what if you annex by ordinance, and at the end of the day, if you're not doing a good job, then they have the right to vote by referendum whether to de-annex? What do you say? Yes, Mr. Fleming?
Yes, sir.
Yeah, you have to speak in your mic and make sure the green light's on.
Okay, thank you. Sorry about that. First of all, I would just say that, you know, we should absolutely be held accountable for providing services. And one of the beauties of 1101 was that if we invested the time in planning, then we knew that we would also be held accountable for providing the services, and that if we didn't, that a judge could remand it back to fix that. So we always have a budget ordinance, a capital improvements program that follows that procedure. Back in the early 90s, when we would annex by ordinance, we would send out an annual report on our progress of providing services. And in that survey form, which we actually worked with some statisticians locally who made sure it was valid, we would say, hey, would you have voted for annexation if you had been asked in advance? And almost invariably, the majority would say no. And then we'd say, knowing what you know now, would you vote for annexation? And the majority would say yes. So there's if that's fear of the unknown is what immobilizes people. And so, being held accountable and providing those services is a critical part. And if we didn't do that, then I would say that we ought to be held accountable and they ought to have the opportunity to consider the annexation.
In fact, I think one of the premises in the preamble, or whatever we would call it, in 1101 was to eliminate annexation out of fear, or conversely, the fear of annexation. That's very interesting that you did the questionnaire in that fashion. Yes, Senator Kyle.
Well, ladies and gentlemen, we've heard some really interesting things in the last 2 months about annexation, most of which most of us had an idea about, some of us didn't have an idea about. But what we really, and there's certain things this General Assembly can do, but there's certain things we can't do. And what we're not talking about and haven't talked about is quite frankly, the fundamental problem that I see that we face as a state is, it's not the providing of services that it's the socioeconomic reason why people live where they live. These small municipalities outside of Chattanooga didn't grow up in order to create services. They grew up because the people didn't want to live in Chattanooga, didn't like the politics of Chattanooga, didn't like the future of Chattanooga. If you look at Memphis, as we heard yesterday, the idea that Memphis might go annex into Fayette County got the lieutenant governor to pass a bill in 48 hours. Which ended up being unconstitutional. But the fact about it didn't have anything to do with services, didn't have anything to do with fire, didn't have anything to do with sewer, didn't have to do with any of that. It all had who was running Memphis. And folks didn't want to be, they voted with their feet. They didn't want to be part of that equation. Now, somehow we have to, in my mind, we have to address that issue and recognize it, while not putting cities that are 15,000 and 10,000 and 20,000 in a holding pattern, which is going to damage our economic development of the state in its totality by having putting barriers to preventing growth. They don't have anything to do with the issues of Chattanooga and Memphis, Knoxville, and Nashville. There's really like two sets of, we got one law here, but we got two sets of kind of communities. And I think I would hope our staff can turn some internal conversation to that particular point. I mean, some of you gentlemen need to realize your towns wouldn't have existed if it wasn't for those big cities and folks leaving them. I'm looking at Mayor Bragg over there. We've all had our philosophies. I'll give you one of Jim Kyle's 10 rules of life. Life is a golf match. Every shot makes somebody happy. And so I'm just saying to you, if we're going to have one size, if there's any flaw in all of 1101, from my amateurish viewpoint, is that it treats your community like it treats Memphis. I just think we're in different businesses. I mean, we're just in totally different businesses providing services that address totally different problems in our society and how we address those. And being totally run by totally different kinds of folks. So and I fear that this General Assembly is going to vote on socioeconomic grounds and not vote on the quantitative side, and that is the danger I think all of y'all who don't serve in the legislature in this room run. Thank you.
Representative Carter.
Thank you, Mr. Chairman. For our panel, and thank you for all the time and effort put into this. You've all done great jobs. I guess the first person I met in this was Bill Hammond, and I developed an incredible respect for him. And when he speaks, I listen, and I appreciate that. And I very much appreciate the great work that you people are doing and doing it right. And no one intends to harm Williamson County and their cities are your cities that do it right. But I'll remind you that very few people violate the law in Tennessee, but we still build jails. And we pass the law for everyone to follow, not just those who go to prison. If I could ask each one of you a question. The current law allows in annexation, non-consensual annexation, for you to annex by ordinance or by referendum. You make that choice at the commission meeting where you do it. How many of you all have chosen your cities? How many of your cities have chosen to allow referendum in your experience? Anyone? What is the reason that you do not give the people the right to vote? You make a conscious decision to go under one side of the statute or the other side. Why do you always go with ordinance?
Mr. Gordon.
Mr. Chairman, I have been mayor of the city of Covington for a little over 8 years now. We have done 2 annexations during that period of time. One was on request by the Industrial Development Board so that property would be within the city limits so that we could provide services. And it was kind of in along a previous corridor annexation. We thought that was a wise thing to do.
I'm about non-consensual.
And
consensual.
Right. The other one was a case of annexing a subdivision. And it was non-consensual, although the people knew quite some time before that our plan was to annex. And the reason was that we partnered with the county executive Huffman to get a grant. We paid half of the matching funds to put in a sewer system for these people who had extensive septic tank issues and those types of things. They asked when we were having public meetings about that process, whether you're going to annex us after you provide us sewer. And I said, well, in all honesty, we probably will, because that was an expense for us, and they were contiguous with us. So during that, as the process played out, we did do that. We had some people come back and say, well, we don't want to be annexed. We had less resistance, and over 65% of those residents ended up with less money going out of their pocket, even after the increase in property taxes, paying city property taxes, than they had before.
And is that the reason you didn't allow them to vote? You knew they would be better off afterward than they realized they would be? In other words, you know what's better for them than they know.
Well, the reason we did it is we had told them ahead of time if we're going to put the services in, we're probably going to annex it.
Oh, well, I understand. Any others of you, particularly Mayor Vickers, why do you make a decision not to allow the people to vote? What is the justification that you put on the record for that, considering the recent decision by the Attorney General under the Voting Rights Act?
Well, as I mentioned in my remarks, we undertaking annexations to close enclaves or donut holes or islands, and we wanted certainty. And that's one of the reasons we changed our charter to allow, non-voluntary annexations, was we had to fix the problem, and allowing those people to vote on it did not bring certainty. Okay, so that there was a public policy reason. The other reason, as I explained, was we are clearly impacted as a municipality by the watershed and the water that flows into it. We made the public policy decision that it was in the best interest of the overwhelming majority of the residents of the town of Louisville that we include that watershed in the town. Now, we understood that may not be popular with everybody, but as I mentioned, there are times as a government you have to take action to the benefit of the many, even though it may impact a few. Now, we tried to streamline that by talking to the people and answering their questions, and we haven't had any legal challenges, and for the most part, you know, I mean, with a very few exceptions, and you never, as you know, you're never going to make everybody happy, but probably overwhelmingly the people have been comfortable with the annexations and the way they did it, and they and 90% of them understood why. But if we wanted to carry out those public policies, we needed to act through ordinance as opposed to referendum.
Yeah, I ask another question. I was interested in your dialogue that annexation does not affect property rights, and you and the Supreme Court may believe that, but no one in my district does, and I don't believe anyone in your district does. And let me give you an example of a gentleman that wrote me. I didn't realize high schools now have skeet shooting teams. They do. I didn't realize that until we got into this annexation battle. This gentleman has a piece of property bought 29 years ago. He has a shooting range built on it, and college and high school teams from throughout the Southeast come to him for him to fit the gun to the shooter. I'm not a shooter, so that's a little foreign to me. Apparently, it's incredibly complex that you make that gun fit the young man or woman exactly. He does that. He is within an urban growth boundary and recently received a letter that he was going to be annexed. And when he went to see the mayor said, well, I can't talk to you because you're not a city citizen. He proceeded to insist and finally got the ruling that, yes, you will be shut down when we annex you. That is retired, and that is his source of income. You consider that not a legal property right under the Constitution, but would you consider that to be detrimental to him, realizing that the county allows it and the city does not? The lady that lives on the other side of him raises a very specialized cow. She's going to have to give up raising her cows, and she's 83, and she sees that as somewhat an infringement on her property rights. So I'd like to be able to tell her why that's not.
Well, and I think it's important that when we talk about property rights, we have enumerated property rights. Okay, and what we're discussing, and I agree with you absolutely that there are certain unenumerated property rights that we have as a virtue of owning property, and we should have rights to the extent we can to do what we want to with our property. But those property, we also have to respect that those property rights may impact others. And I would hope in that instance that that situation could be solved. Listen, I'm the son of a Tennessee farmer. I understand the need to preserve and protect agricultural land use. Okay, but I also understand that as we grow and as things change, we may have to preserve and protect that in different ways. Okay, but I would hope you don't see me and the others as the mayor who says I don't want to talk to you because you're not a resident.
Well, I don't. I think the cream of the crop's here, and I.
But I would hope all of us would talk to anybody that, as would you, that walked in your door and said, I have a problem that I want to talk to. But there are times that we simply have to look at the impact on the community as a whole, and we have to weigh that versus individual rights and what they want to do. And it's never easy, and we're not always going to get it right. But that's there are times that we have to make those hard decisions.
So to this man and woman, they called me this afternoon because they're watching this now. I assure you, I'm going to tell them that the good of the community outweighs their right to enjoy their property as they have for more than 40 years.
I understand that, and there are things that, you know, I enjoy shooting, and I would like to walk out in my backyard and shoot. But I don't do that because it's not in the interest of the community. And so I have to, and it's not hard. That's a hard choice, and that's why we need to understand that we have differences in our municipalities, and we need to recognize that. And you know, as somebody told me when I ran for office, you know, this governing thing isn't easy. Okay, you're going to have to make hard, difficult choices, and you're going to have to tell some people no, and you're going to have to make some people mad. But if we're committed to doing what's best for our community, sometimes we have to do that.
Well, as I told Bill Hammond one day, and I think in my office or maybe in the hall, we talked so much, if everybody ran a city like you did, I wouldn't be here probably. So, listen, I understand that, and I appreciate it. But as my research shows, Mayor, your city is a defensively created city, is it not?
Well, before we get off that topic, can I
Maybe
answer?
Google has it wrong, but the research shows that you all were incorporated so that you wouldn't be annexed.
Well,
Now that shoe's on the other foot, and I don't understand the change.
well, there
Mr.
was,
Carter, wait, I hate to do this, but since Mr. Hammond's name was called, could he respond, and then Mayor Bickers, and I know Mayor Gordon wants to weigh in.
I know it's standard practice in our area that if we annex an individual or a land, excuse me, a land area, if there's a non-conforming use or a non-conforming activity, they're grandfathered in. They can continue to do those, so they don't have to stop doing that. If she's raising a particular type of cattle and it's not deleterious to something else, and they've got a shooting range operation that's contrary to what the new zoning requirements would be, as long as they continue to operate those two things without a lapse, then they're grandfathered. They can continue to do it. You can't make them stop.
Thank you. Representative Carter, and then you were engaged with Mayor Bickers there.
The
I'm just wondering if my quick iPhone research is correct on that.
in some respects that's correct, in some respects it's not. There's no question that there was concern at that time about not only Alcoa, but there was also Mayor Ash at the time, and Knoxville had even expressed some interest in coming across the river. And so there was a lot in play at that time. And I won't dispute that there were people who said, we don't want to be Knoxville and we don't want to be Alcoa, we want to be Louisville. But part of what we've undertaken, because as we sat back as a community and as a town, we decided that, we don't want to exist because we don't want to be somebody else. We want to be who we are. We want to put together a form of government that fits our community, and that's why one of the few that we recently passed a home rule charter to recognize the culture of Louisville, the different ways we want to govern. And so while 20 years ago, undoubtedly concern about Knoxville and Alcoa was at play, today we do what we do, and we exist because of who we want to be and who we want our community to be.
May I ask one final question?
Yes, sir. Thank you.
I heard the thank you. 35 states require referendum. 47 have extreme restraint between the 35 and the 47. I noticed our research from TACIR said Nebraska does not. However, Nebraska exempts over 67 million acres of property from annexation under any terms. So I include them, and I'm back to 47. How do cities grow throughout the nation except for 3 states, and we can't do it in Tennessee? Thank you, Mr. Chairman.
Vice Chair, would you like to respond? Anyone like to respond to that particular? Yes, Mr. Fleming.
Just a quick response. We go on recruiting trips to recruit residents to consider retiring and moving to Tennessee. And when we're in Chicago, for example, and they say, what are the property taxes in your town? And we'll say, well, it's $1,000 for the city, $1,000 for the county. And they go, is that a month or a year? And we go, that's a year. And they go, golly, we pay $20,000 a year with all the layers of government and utility districts and special districts and parks districts, and every one of these has a taxing authority. And so I think that what we have here is a pretty good deal. And, to Senator Kyle's point, we have a range of sizes of cities, and all of those boundaries were pre-negotiated. On the committee that I worked with was the town of Farragut. I couldn't help but think, in 1980 they were created to avoid being annexed by other cities as well. But now they have an urban growth boundary that's been pre-negotiated, and everybody signed off on it, and everybody knows what to expect. So I think that certainty and allowing that, predetermined growth helps us keep those costs down and keep Tennessee very competitive long term.
Vice Chairman Rowland.
Thank you, Mr. Chairman. I wish Representative Carter represented me because he's so dynamic. Thank you, sir. We've talked about the cookie cutter approach not fitting everybody in the state, and I certainly agree with that. Mayor Gordon, you mentioned the Industrial Development Board asked for a potential industrial site to be annexed. Now, on that industrial board, I'm sure there were county representatives, as they are on all of the boards. Same thing happened to us. The county folks wanted a new industrial site in Bradley County to be annexed into the city to get fire protection and the services. Judge Carter, we had a skeet range in Cleveland. We annexed the area, and houses were around that area when it was in the county. Well, it still is in the county. We forget that sometimes. But we allowed that skeet range to continue until the man wanted to retire. There were no new buildings built. There was nothing that put anything in danger. So I guess there's no cookie-cutter approach. The instance you referred to was different from our judgment, and maybe the difference from judgment of other cities across the state of Tennessee. We talk about, I like islands instead of donut holes. I think that sounds more romantic, maybe. Yet healthier, too. But as I mentioned, I believe yesterday, we have an industrial park inside of Bradley County, a $2 billion investment. The folks would like to be inside the city for various reasons. We'd have to have an island of about 5 miles to annex these people. Another industry close by, similar to one that Mayor Bragg has, I understand would also like to be in the city for the same reasons. And we'd have a long donut hole or island to get there. So I just say that to say we're all not alike. But in my opinion, I never thought I'd be defending Chapter 1101 when it was passed. But I do today. I feel strong about it. It's been fair. As far as having a voice in being annexed, my city manager is here, Janice Castile, and we were talking yesterday about this very issue. We have just recently considered annexation of some areas, and we conducted our public hearings, and we decided not to annex because most of the people that area didn't want to come in. We had one gentleman who was a builder building a subdivision. He didn't want to come in. Then he came in and about a week later said, please annex me because I figured out I can build more lots with the sewer than I can with septic tanks and field lines. He gained about 9 more houses, so he's going to have more revenue. So we're all not alike. We're all different. And Judge Carter, I understand certainly where you're coming from because I witnessed a lot of that. But I think what affects Hamilton County and maybe Chattanooga and Ooltewah certainly doesn't affect Cleveland and Bradley County. Thank you, Mr. Chairman.
Thank you, Mr. Rowland. Let me put this question to the group, and that would be that we're coming up on the end of 20 years. I guess we're at about year 15. I haven't checked again, but so we had the 20-year growth plans. What, if anything, in your opinion, should happen as we approach that 20th anniversary? It's an open question. The law, I'll admit, doesn't require, as I remember it, that the plan was only good for 20 years, but there are some who look at it that way. This may present an opportunity on the eve of the 20th anniversary to review the 20-year growth plans and see how some folks are doing, because in some cookies that were cut, municipalities just cast a very broad net and said this will be our urban growth area. And if you look today, you might find that they really haven't expanded into those areas in a significant way at all. And so it's a fair question for folks to say, should that be reopened and reconsidered, and should those be reconfigured? And I know people wince because they don't necessarily want to go through that again. But maybe that's why. A lot of what is in 1101 was dependent upon an informed and engaged electorate. And so, you know, with the passage of soon an entire generation, inevitably you're going to have folks who don't know about the urban growth area in which they live. They weren't old enough to be informed or engaged at the time, and nobody's taken the time to remind them. So maybe by force of law, we're coming up on a time when everybody of necessity should be reminded as the 20-year plan expires. Mayor Gordon?
That's one reason I keep my hair cut like it is, so that I won't have the temptation to pull it out. I think we ought to look at our urban growth boundaries, go through that process again. I think there's a lot of planning that we need to be doing because the young people of today look at where they want to live differently than we do, or at least most of my generation. They want walkable communities, walkable neighborhoods that have a variation in services. And for instance, with the city of Covington, our airport, our municipal airport, is outside our urban growth boundary. That happened before my time. I would like to see it corrected, but I don't want to see it corrected enough to go through the process as it exists now. But I think it ought to be looked at. So I would agree that we need to look at all aspects of this. And for Representative Carter's issue with the two people having to change what they're doing with their land, my answer to that is I think that's a preposterous stance, that they ought to be able to continue to do what they're doing as long as they want to do that, even if they're annexed.
Mayor Rowland.
Just quickly, thank you, Mr. Chairman. When I mentioned I'd like for Representative Carter to represent me, that doesn't mean exclusively, but in addition to Brooks and Watson. Thank you, sir.
We were just going to move on. You know, it's sort of like, we really would, okay, let's just move on over that. Other members, questions, comments? Mayor Waters?
How would you all react? I know we're talking about 1101, and initially there was a 15-year window where the revenues, in particular the sales tax, would continue to go to the county, and then after that 15 years, then they would revert to the city. But as a lot of us have forgotten about that and just now reminded of that, and I'm reminded that I'm probably going to, Sevier County is probably going to lose a couple of $100,000 next year. How would you all react to some kind of phase in over a 3 to 5 year period, so much each year, instead of losing it all in one fell swoop, to a phase in of revenue that the cities would get back? And I'm just pulling this out, 20% a year over 5 years, and at the end of that 5 years they get the total amount back, which would help, I think, a county government to adjust better to the kind of revenue loss we're talking about. How would y'all react to that?
Mayor Waters, certainly that's a plausible way to go, but you know, the whole notion of the 15 years was to actually do exactly that over 15 years. So when you got to the end, then you've transitioned that and you're prepared for it, and you're ready to go. So that's what we've been counting on, is that at the end of the 15 years, then the county has amortized that transition period out, and so finally we'll be able to start getting revenues that we're probably servicing the account of those individuals and stores and businesses and whatever.
Mr. Fleming?
I would just add that the 15 years is after each individual annexation. So, you know, it's kind of stair-stepped over a long period of time. So whatever transitionary period needs to be worked out, I mean, I think we'd all be willing to talk about anything like that. We don't want to hurt the county. And Chairman Norris, just to address your question from earlier about after 20 years, what with 1101, I think anything that you can do to keep cities and counties engaged seriously around the table, making local decisions about growth planning, that can never be a bad thing. So whatever comes after 20 years, I think, you know, we ought to encourage and have a reason to sit down and think how we can plan for making a better future for all of us.
Thank you. Yeah, would you like to yield to Senator Kyle? All right, Representative Carter.
I hate to say it again, but I feel like it's necessary. 1101 is a great bill. Whoever put it together spent an incredible amount of time, and I respect that. Throughout this, we have talked. Each one of us have heard that it did its great work. It brought the cities and the counties together. Just now, let's make sure we bring the cities and counties, keep them at the table. I'm here to say let's keep the cities, the counties, and the people at the table. Not one time in this committee has anyone mentioned communication with the voter and the person directly affected, and I'm stunned by that. Thank you.
You mean in today's proceedings, Representative Carter? You recall me talking about the rights of citizens as opposed to the rights
no question.
of cities.
But I'm saying when we talk about what good came out of 1101, we cause the cities and the counties to talk. Why don't we cause the city, the county, and the citizens to talk? We did a great thing. Now, listen, I've been in county government a long time, as Mayor Rowland knows, and we needed it. But, guys, we're to the point now where we need to bring the actual voter into the process, make them an equal party to it, in my opinion. One final thing. I very much respect each one of you. Each one of you is doing a great job. I say that with all sincerity. Bill Hammond won my respect from the very first day I met him. He's taught me a lot, and I admire that, and I appreciate it. In fact, he's asked me to come up next week and go around and look at some things with him. I'm happy to do that. I'll learn a lot. But to me, that's the very reason referendum will work. The good cities, we can't do a cookie-cutter approach. We can't do something to Mayor Rowland because of something that happens over in West Tennessee. The referendum will allow each community to tailor their needs to the voters. That's the only way I see to make this non-cookie-cutter, non-damaging to the good guys, but respectful to those who don't perform the services that you do. So to each one of you, thank you for the great work you do, and I'll support you in that in every way I can. Thank you, Mr. Chairman.
Senator Kyle.
I just wanted to, I guess, as much to staff and to our folks here. We talk about annexation, but really there's two types of annexation, it seems to me. One is the industrial office park site that folks want. The Amazon distribution center wants to be in the city, so they, whatever. That to me is an entirely different concept than the annexation of voters. It would seem to me, as we talk about this, that there should, if a city or can show under a certain criteria that that's what we're doing, then you go down one path. If you can show that you're not, that's not what you're doing. If you can't show you're doing that, it seems to me, then you've got to go down another path. Now we'll get to whatever that other path is, but it just seems to me that's an example of two animals and what is an appropriate thing to take. I would, and when we keep talking about when these folks just want to be annexed into their cities, I would imagine that ultimately there's somebody's going to have some kind of business operation. They're not going to want to be annexed into the city because they might not, well, quite frankly, they might not like the people who are running the city and don't trust their judgment. You just don't know. I mean, you never know. But I'm just saying to you that we need to recognize that, and I hope the staff would think about that as to that if you can show one set of parameters, you go down one road. If you show another set of parameters, your default is to go to another side. And I would just raise that point. We could take that issue off the table. I think our discussions would be more to the more difficult side of it, which is the political side of it.
Duly noted. Mayor Rowland.
Thank you, Mr. Chairman. In response to my friend Representative Carter mentioning that we have not included the people, I would reaffirm the public hearing process, not only in the Planning Commission, where people go and let their opinions be heard, and then I think Mayor Bragg's city passes annexation on 3 ordinances, 3 readings. We do it on 2. So we have the public hearing for the plan of services. The people come. We have public hearing on the annexation itself, and the people come. They're welcome to come. Many do. And then we have 2 readings on the ordinance, and people still come, and we give them an opportunity to express themselves and listen to it. And we've listened. We've said no a time or 2, and we've said yes. But we have talked about the people. Thank you, Mr. Chairman.
Senator Henry.
Mr. Chairman, gentlemen, ladies, this has been very interesting to me because Davidson County is not affected. I would like to recommend to all of you that you look carefully at the metropolitan form of government. It doesn't just apply to big counties like Davidson. More and Trousdale are now metropolitan. Before we adopted metropolitan government, an aggressive policy of annexation was carried on by the then city government. And I know let's see, I was included by half a block, and the street light went up outside my bedroom out there and so forth. But anyhow, everybody has pros and cons. But it's been a very good thing because everybody participates in what the government does, and the Urban Service District, which provides you city services, comes out by an agreement of the council that recommends everybody, those folks inside and outside. On the mechanics of it, I cheerfully yield to my colleague, Mr. Charlie Cotwell. He knows it inside out and backward and forward. But generally, that's how it works. It avoids what you're talking about, Representative Carter. It avoids annexation without consent because the parties give the implied consent when they vote for their councilman. So that's all I had to say, Mr. Chairman.
Thank you, Senator Henry. Good. Yes, and Senator Kyle.
I have to tell y'all this as Henry brought that up. The other day I was going through some papers and I came across an old blue book. I mean old blue book. I'm talking about a blue book from like 1962 to 1964. And in the blue book, they had the various pictures and government and whatever. And on one page it says, "This is the governor's executive residence located near Nashville." So at least in 1962, they didn't think the residence was in Nashville. They thought it was near Nashville. So I would say folks had a different perception of what Nashville was at that 50 years ago.
You've been looking at pictures of that governor's residence, I hear.
But one size doesn't fit all, Senator Kyle.
Not measuring for Kurt.
I would say there were some relatives in that book. I have to.
Thank you, Senator Kyle. All right then. Unfortunately, we need to wrap up this phase of our discussion this morning because we have one more item to take up on this morning's business. But I want to thank you again individually and on behalf of the entire commission. It's been very good. Let's make sure that for those of you who reduced your reports to writing, we get copies of those, please, because we'll benefit from them greatly. Thank you very much. Thank you. Thanks for taking the time. And as they depart. Members, you'll see that we have the final item behind tab 5, and Ethel Detch is in the house, and she is going to give us an overview of a draft report on transparency in government, and it's really quite interesting when you begin to consider all that she has covered and is covering in this report. And it's like many of the things we do at TACIR, it's not something at first blush that you would ever even think about looking into, but fortunately we're doing that. So Ms. Detch, the floor is yours.
Thank you, Chairman Norris and members of the Commission. I'm really pleased to be here this morning to share some of the work and the thinking that we've been doing on the subject of government transparency. Our draft report can be found under tab 5. Now, the citizens' desire for information about their government is not new. It goes back to our nation's founding. But in recent years, it has received a particular emphasis, in part because of the advances in technology that we have. It makes it possible for people to access so many kinds of information with just a click. People have come to expect that immediate response, whether they're ordering a shirt off the internet from a business or whether they just want to know when their trash is going to be picked up. So the ability of governments, though, to keep up with some of that and to think about it depends on a lot of things, their structure, their financial and staff resources, what their citizens may want or need. In many parts of our state, we may not have enough connectivity to really do it. And what kinds of information does the government already have collected and stored, and what form is it in? As you know, as we've just been talking about, our governments themselves vary a great deal across this state. We have the state government plus our biggest cities, and then we have some very small counties and towns that are in very remote locations. So consequently, a one-size-fits-all solution probably doesn't work well with transparency either. But we did identify some ways that we think all governments can probably think about this and be more transparent. The 107th General Assembly referred two government transparency bills to TACIR. One addresses state government, one addresses the local governments. The first Senate Bill 2831 would have been known as the Taxpayer Transparency Act. It would have required our State Department of Finance and Administration to create and maintain a searchable budget database website detailing where, for what purpose, and what results are achieved for all taxpayer investments in state government. The second bill, Senate Bill 2832, House Bill 3328, was known as the Local Government Transparency Act. It would have required every county, city, and school district to create and maintain a single searchable expenditure and revenue website database that would allow the public to review information concerning monies collected and spent. Both bills included features such as searchability, and before I get done here today, I'm going to show you some examples of searchability and what that means. Historical data and information at the checkbook level of what governments spend and listings of their contracts. Because these bills were mandatory for every government in Tennessee, the fiscal notes indicated that it could be pretty costly for, particularly for some places. It might not have been as difficult for the state government and the largest governments, but it could have been very costly for some of the smaller ones. At the same time, though, we noticed that the requirements of these bills really didn't cover the full range of public information that people may want. It was very focused on fiscal information. So what do people want to know about their governments? I realize it's kind of a hypothetical question, but we assume that taxpayers want to know that their money is being spent wisely and well, but they do want other things too. They might want to know whether a nursing home where they've just placed an elderly parent has good inspections or not. They might want to know if they're looking at a house. They might want to know, is that house in a floodplain, and how much are the property taxes? Proponents of improved transparency generally believe that making more information available will make our government officials more accessible and accountable. They believe that it will reduce government waste and abuse by making things more visible, that it will provide useful information for people who work within the government, that they will also be able to benefit from what's online, that it might help us identify trends that we wouldn't have seen otherwise, and that it will free up government employees from responding to routine information, like what day is the trash pickup, from residents, from media, and other interest groups. So when I first got this project, my first reaction was, well, what's not good enough about the Public Records Act? Because doesn't government information already have to be public and accessible? And the answer to that's yes. Tennessee passed that version that we have in 1957. But here's the difference. The Public Records Act places the burden of responsibility on the requester of the information to know what it is they want, where it is, how to ask for it, and then once they ask for it, to sit around and wait for it. Transparency legislation shifts the responsibility to the government to proactively post information without being asked. In addition to the State Open Records Act and some other state laws that affect specific departments, government transparency has been influenced to a great extent by federal laws. And these are listed on pages 11 through 13 of tab 5. In addition to our State Open Records Act, the Federal Funding Accountability and Transparency Act, the American Recovery and Reinvestment Act of 2009, and the Freedom of Information Act have all had an influence on state and local government efforts to make information more available. So I wanted to get a sense of what Tennessee is already doing in this area. So I looked at Tennessee's state government. I've shown up here on the screens is what Tennessee's transparency website looks like at the moment. This is accessible from the bottom of the home page, the tn.gov. And then I also picked some counties and cities and school districts just to see what was out there. And I tried to pick varying sizes from all 3 grand divisions. There's also a picture of this on page 5 of your report. This particular site has been there for a few years, and the governor's staff indicates that there's going to be a new one of these rolling out in early 2014 that will have some additional features and some additional information. If you looked at this page or went looking for it, it is available from the state's homepage, which to me seems like common sense, but actually when I looked at some other states found out that it's not. But I think it's helpful for an uninformed user. As you can see, it has information about meetings. It has links to items such as vendor payments, the state's comprehensive annual financial report, the CAFR, the budget, state employees' salaries. It also has a method to provide some feedback to someone about the site. These are fairly common items on transparency websites. In contrast, though, some of the other states we looked at had several additional items, which I'll talk about. They may have also had maps and graphs and charts that help a user understand what they're looking at in the government. After I'd been dealing with this issue for several weeks, I also became aware that the Department of Economic and Community Development has also launched its own open government website called OpenECD. As you might expect, it's geared toward business. It has information on tax incentives, various ECD reports, and information about grants that have been awarded. It is not very easy to find from the state's homepage, though I would add. I'll see if I can pull this up. Here is ECD's transparency website. I then turned to the local governments. As you're aware, our local governments range in population from Memphis, 647,000, to Salisbury, Tennessee, population 81. Counties range from Shelby, 928,000, to Pickett County, slightly more than 5,000. So some of these governments provide many, many services. Others provide just a few. And as I mentioned, several places are located in areas that don't have good internet connections. Statewide, of our 95 counties, about 2/3 of them have their own website. Many others of them partner with another local entity, such as a Chamber of Commerce, to provide certain county information. With the cities, I used some information from MTAS that indicates that about 203 of 345 municipalities have their own website, and we don't really know. Some of the cities, I think, also partner with other entities like a Chamber of Commerce, but I don't know that particular number. So to get a sense of these, I picked a sample, and if you look at tables 1, 2, and 3 that are located on pages 9, 10, and 11 of tab 5, it gives you an idea of what kinds of information were on the local government websites and what were not. I would caution these are preliminary. It may change some when we do the final report. Of the 15 counties that I reviewed, 11 of them did have their own web page. 3 had some of their county information on a chamber website. 1 had neither of those, but the school district itself had a site. Several counties posted information about their elected and administrative officials, their open meetings information, such as times and places of meetings, agendas and minutes. Some had links to their budgets or their audit reports, or maybe posted them directly. Some of them had websites that were generally searchable. Only Knox County, though, had any searchability down at a transaction level. The cities were similar, although, as I mentioned, several of them had no website. The most common item that I did find on city websites was a link to the city's charter. Most of these were on MTAS's website, and I mention this because we think that making better use of links to existing information may be an economical and easy way for many of our smaller governments to improve their transparency. And I would also add that some of our county governments have scored very well on transparency nationally. Knox, Shelby, Williamson, and Wilson are 4 of those. And I had planned to use Knox County today. I guess Knox County's Open Government Portal had been my poster child for this presentation. On Tuesday, the county launched a new website, and the portal's no longer there. So I called and talked to them, and they said, actually, it didn't get a lot of use. So maybe that's something else to consider in this. And other places have said that it's the media. So anyway, I can't show you how great Knox County was doing.
Ms. Detch, I'm going to interject here. If you know, it's me, because to that point, and for those who may be watching or access this in video archives later, there's an irony in that. I had the privilege of speaking to a group in my district in Covington earlier this week, and I was sort of giving them the top 10 for Tennessee, all the accolades that the state has been given in various categories, whether it's, you know, the Chambers of Commerce, Forbes, you know, our progress in economic development or low taxes or per capita debt, all those things, and I had at least a dozen come up afterwards to comment that they didn't know all this stuff, and the first reaction makes us feel, oh, well, we need to do a better job communicating. And yet when I sit here and see the wealth of data that exists now online, at any rate, I think maybe the problem is, you know, perhaps we're just not pointing them in the right direction, that they don't know and they're not accessing it, to Knoxville's point. But for those listening in, that's what this whole transparency report's about. If you think you don't know what's going on, it's not because we're not trying to, the state anyway, is not trying to make this information available. So it's one of the reasons the report struck me as very important. Thank you for letting me interrupt.
Sure. I guess we did try to look nationally to see what groups might be interested in transparency and promoting it. We found 5 different organizations that have promulgated some sort of a model for government transparency, and 3 of those actually rank states. One of these, the U.S. Public Interest Research Group rankings, I've included in the report. On this particular set of rankings, Tennessee gets a C. So we decided to take the A and the A- states listed here and compare them to Tennessee's site and see what do these states have that we don't, what are the differences. And the results of that comparison are summarized in Table 5 on page 21. We did find that all 7 of the A states had checkbook level expenditures that you could drill down to individual transactions. 6 of them could be downloaded into a spreadsheet so that you could work with it. 6 of them had ready access to all their contracts. All 7 of them had graphs and charts to help users understand their expenditures. In the last few days, I've also looked at the F states to see if I could tell anything instructive about them. The problem is that I looked at them later, and I think some of them may have made changes since these ratings came out, although maybe not. There were some that maybe just chose not to. Some of them had laws requiring transparency but had not implemented it for whatever reason. So what makes for a good open government website? I think it's important. I think just what Chairman Norris is saying, websites are a tool. That's all they are. They're a tool of communication. So we have to keep that in mind, that some communication may be helpful, some may not. A good website needs to reflect its government. It needs to be easy to use for people. Government officials really need to strive to determine what information people most want. Websites need to be comprehensive, understandable, usable, and implemented with the least possible cost. At least those are the criteria we came up with. So if we look at the concept of comprehensiveness, it needs to reflect the overall functions, responsibilities, and performance of any particular government. Governments, as we know, have many parts. They may or may not work well together. Sometimes the constitutional structures get in the way. Sometimes we have split partisan control. Sometimes we just have very disparate functions where one part of a government doesn't work well with another. But I think it's important to think about people looking from the outside at the house of government, that they see some kind of a united front or can figure out where they need to go. And I experienced this when I looked at Florida, which was an A- state there. Florida actually has 4 transparency websites, and if you go to their main page and try to find those, it's just confusing, and I think they've are trying to fix that now. Websites need to be understandable. If we post complex organizations, that may be helpful to start. It's definitely a step in the right direction. But if we just overwhelm people with a lot of data, with budget documents and CAFRs, it may actually have the opposite effect. People may feel less connected to their government and more confused. But if we can explain how to use some of these documents and provide some illustrative aids such as maps and tables and graphs that helps them understand, that may be useful. And I hope I can pull up Kentucky's I'm going to try to just show you a couple of graphs that they have used that I hope will illustrate that. I think you can see here there's a pie chart, and then well, come on. You can see it just pulls up a graph. This is all of their funds appropriations. If we just want to look at general fund expenditures, it has a nice table that comes up. Just using things like that kind of helps people be able to see better what their government is doing. Government websites need to be user-friendly. Think about somebody coming to it who doesn't know about the government or how it's structured. To illustrate this, I've chosen a website from Douglas County, Colorado, which has won a lot of national awards. And the main thing I want you to see here are the tabs that we have across the top. This strip where it's got Douglas County, the services, government, business, land use. Over on the right it does have a transparency tab, and if we look at that, you can easily hit transparency and then get to all those things that are below it. Some of those you can probably get to from other places as well, but this is just one page. You can look at it and easily get what you need. I did talk to the woman who was responsible for promoting this there. She said they didn't have a law, they just have a culture of openness within their government, and it evolved from that. So I thought that was interesting. Finally, we think that transparency should be improved at the least possible cost. It's going to depend on what information is already collected, how sophisticated websites are, if they even exist, how much effort is needed to add or to change information. Some states have incurred some large costs to make transparency a priority. Others, like our state, have incorporated it into some other changes as they've made them without incurring really large costs. So providing more information online is also going to depend on what your government already does. And to illustrate this, I guess my former life, I looked a lot at the Arizona Auditor General's site. They have a division that all they do are school district performance audits and financial audits. It's a whole division just dedicated to schools. So obviously Arizona is going to have a lot of information collected about schools that Tennessee doesn't. So for us to to be compared to Arizona in that regard creates there are some big differences that would be difficult to overcome. We also need to consider cost savings. The fiscal notes for the original bills never addressed anything about cost savings, but some of the governments actually report that by increasing their transparency, it's helped free up their staff so that they're not dealing with routine requests, and some report that they were able to see trends in their government expenditures that they would not have seen otherwise. Last week there was a Wall Street Journal article that talked about how the city of Chicago has put a lot of information online and then allowed private citizens and the private sector to develop all kinds of phone apps from it. There's over 90 phone apps that help citizens get around in the city of Chicago, so that's another aspect of it. I want to show you the Texas site. Texas was the only state to earn an A on the U.S. Public Interest Research Group site that we looked at. Texas, I think, is not always a great comparison state for Tennessee because they are so big and because they have a pretty different government structure in some ways. This was probably the most expensive state transparency website that's out there. It's run by the Texas Comptroller of Public Accounts, and just for people who may not be familiar, that's more like our Commissioner of F&A, although it is a publicly elected office in Texas. But I wanted to show you, this is where I can give you an example of what it means for the searchability and being able to drill down to the expenditures. So for my example, we're just going to do some spending by agency. If we say we want to look at the 2013 expenditure for we'll pick the Attorney General because they start with an A. This will come up with all of their expenditures for that agency. But then say we want to know about their travel expenditures. We can click on travel, and it will break it down into all their different object codes. And then if we want to go beyond that, it actually gets down to, you can see here, individuals and their travel claims in the Attorney General's Office of Texas. So this is the level when they're talking about searchability, this is what they're talking about. So I just wanted to show you that so that you know. If we use our 4 criteria for comprehensiveness, understandability, usability, and cost, we can begin to view this idea of transparency on a continuum from maybe some modest voluntary alterations all the way to comprehensive mandatory changes. And the appropriate option for any community is just going to depend on some of those factors that we've just talked about. And different communities may want more or less. When we talk about the citizens, we need to figure out what do the citizens want in any particular place. The first step on this continuum might be to not make any changes at the state level. Let things progress as they have. Some governments will continue to improve their transparency, others won't. Some governments clearly have been motivated by some of the transparency rating agencies, but those groups do tend to look more at the larger governments, not our smaller ones. One moderate way that we thought we might be able to improve transparency in the state would be to create a statewide task force, which represented a lot of different interests: the citizens, the businesses, different levels of government, educational institutions, IT professionals. Bring those people together and let them talk about this and share what they've been doing in different parts of the state and challenges they face. That group would not have to be long-lasting. There are some other states that have created kind of an advisory committee for their transparency websites, but we think it would increase the cross-fertilization of ideas and raise awareness. The task force and the governments themselves need to ask what kinds of information people actually want. While most of these advocates are focused on fiscal information, all entities are funded with public dollars. They perform functions on behalf of the public and have some obligation for transparency. A second option that we thought of would be to make better use of existing information. As I pointed out, the MTAS, all the city charters on the MTAS site were one, but the Controller's Office has all of, or most of the local government audits and financial reports. Our State Department of Education has report cards for all our school systems. Those are just some examples where the information's already there, and even a small government with a not very complicated web page could probably add a link or two that would help be informative. We might, if we wanted to do more, could establish some minimum transparency requirements, perhaps a list of basic information that we could encourage or require every governmental entity to make available. That list could include things like who the elected and appointed officials are, include their agendas and minutes from meetings of councils and commissions and boards, fiscal information such as we've discussed, but also any regulatory information they may have, licenses, permits, inspections, complaints, and all governmental entities should probably post directions for how to submit an open records request. This might be an option maybe for the mid-sized governments, although several of our small ones already have some of these features. We think that there's probably a need for some differentiation between the very largest local governments and maybe the mid-sized and small. If we look back at the proposed legislation that was actually sent to us, these two bills dig way deeper into financial data than any of the other options we talked about, but they were less comprehensive in other ways. So if we implemented the requirements of those bills, just the sheer amount of information we think might be overwhelming to some users at least. Most of the governments would probably need to upgrade their technology. But regardless of the approach that we take to transparency, we also need to be careful to protect information that various laws already exclude from disclosure, different things that are confidential. And policymakers may just want to consider, would anyone be unintentionally harmed, I guess, by the disclosure of certain kinds of information. Overall, we conclude that transparency can certainly be improved in all of our governments, but that a varied approach would be appropriate, that differentiates among sizes of governments and function. I'll be happy to answer any questions.
Any questions for Ms. Detch? And you'll have your final report. Senator Kyle?
Very briefly, did y'all look at the use that the public, I mean, it's not their way to track how many times someone goes on to a certain site and determine whether or not, whether we're building something that people are using or we're building something that looks pretty good to us?
There is a way to track that, and we can actually include some of that. I know with the state's site we have some of that, and I know when I talked to the woman in Douglas County, Colorado, she said that the media are actually the main users of their transparency tab, and that's, but that is indirectly, I guess, providing stuff to people. But yes, I think that's is a good question, is who wants it and who's using it, and do they want more, do they want less, is this what they want?
Well, it does seem to me that some of the stuff, a lot of people use it for commercial purposes. They're not using it out of just curious of what's going on. And then you got to, if that is the case, then why are we providing that service if it's for a commercial basis? I mean, for instance, you may be surprised, I know Senator Norris would be surprised to know there are people who actually will sell their services to do background reports on potential candidates who are running for office. And track their track that how you vote and what you voted for and whatever, and thanks to the Tennessee General Assembly, they can do that from the luxury of their home, because they don't have. They can just sit there and do it. I would just say to you, that's a commercial purpose. I am very interested in knowing how much money we're spending on a product that the general public either doesn't have the capacity. For instance, you don't have internet access in your is widely available in all counties of the state as others. But I'd be interested in knowing that we look at the tracking of information and how many people going on that website. I mean, I've generally found that the design of most of the websites are to keep you from calling them. I mean, there's no phone numbers. And I mean, if you just, I mean, you can spend 10 minutes on a county's webpage and you can't find a phone number, whatsoever. I'm not saying that's an accident. I don't know, but it just seems to be that sometimes I'd be curious as to what need are we filling, who are we filling the need to, and what is the volume of the need. And I think when you finish your report, I'd like to hear something about that.
I would say Tennessee's approach has been to kind of do things that they were already going to do. I guess in providing the new website, it's going to be, because we have, there are now some tools available for the state's Edison system that weren't there before. I think they've tried to incorporate things as they go rather than having a special expenditure for this. But I think that's a good question, and I don't know about, I guess ECDs. I don't know as much about it, but I don't know if Paula has anything about that or not. But we can find it. We'll find out.
Mayor Huffman.
Thank you, Mr. Chairman. Ethel, I believe the statute still requires local government public notices to be published in a newspaper of general circulation, in most cases anyway. If that's the case, is the newspaper required to also put that notice, if they've got a digital subscription service, to put that notice in their digital paper as well, or not? Because you see my point. We're going toward more folks are reading the digital than the printed newspaper, and it could be that we're following the law and putting public notices in the newspaper of general circulation, but folks, when they're reading the digital subscription, may be or maybe not getting that information. Do you know?
I don't know the answer, but we'll try to find that out.
Yeah, I'm looking at our daily publications website now just to see quickly in the index. I don't see that they have the classifieds or the equivalent on here. I may be missing that. So in the Rutherford County,
and it may be that it varies from newspaper to newspaper. I just don't know. I don't know if it's uniform or not.
Yes, sir.
Mr. Chairman, I can reflect a little bit about that in a small rural community. In most small communities where you have one newspaper, one media outlet, or one radio station, there is not a public notice. There's a public notice section, but most of the time, if you're having a governmental meeting, it's posted as a story. So it ends up, instead of being in the public notices, it ends up being a story at the bottom of the front or second or third page or something like that. So when you look at it online, and most every newspaper I know of is online, it is there as a story that certain group is meeting at a certain time. But I'd also like to, Mr. Chairman, just reflect a little bit on that the online, this is very attractive for small rural counties because, and I know from experience, you don't have the resources in some of the offices to be able to sit there and track down copious amounts of public records and make copies for them, and that's been done before. There's just not the staff to be able to handle that, and so having it available digitally online has really helped out, especially in small rural communities. And you just don't have time to take all those calls. And I mean, it used to be that it was when you were given a notice, you would have to make all the copies of all the pages. You could charge a minimal fee for that, but you'd have to make all these copies, and that's taking someone that is overstressed and overworked anyway a whole lot of time out of their day to be able to do that. So having it digitally has really helped out, and especially in small communities. Thank you, Mr. Chairman.
Thank you. Ethel, where are you? Are we done?
I'm done.
Any questions, any additional questions, comments, Mayor Waters?
I assume that if the legislature passes the Local Government Transparency Act, they're going to appropriate the money for us to implement it, which would be $7 million on the front end and some $3 million annually. Is that?
Let's not get carried away, Mayor Waters. Come on. Unintended consequences. Well, we'll look forward to your final report then in our October meeting, I think. Is that right? August? October. And if others, we've had a few comments here about the tracker and that sort of thing, but if you know of any changes you'd like to suggest now, feel free to offer them. And Senator Henry?
Mr. Chairman, at one time I thought I represented the Attorney General. Later said I did not, but for years I did. A town in Dixon County with less than 100 people. If we recommend one of these bills, any town under a certain size ought to be excluded, I think, because of cost. Because if there's a small number of people down there, if they live there, they'll know what's going on anyway.
It's already transparent, right?
That's right. That's right. Thank you. Thank you. Thank you again, Ms. Tetch. Thank you very much. All right then. Well, we're about to conclude our orders of business here. Is there anything otherwise that folks would like to address at this time before we move on to adjournment? You'll see in your notebook that our next meeting is scheduled for October 23rd and 24th. We'll have the final report on transparency and draft reports on insurance versus surety bonds, outside water rate setting, and continued discussion. At least we'll have a draft report on 441 and Senator Kyle, and then
Has this commission ever issued minority reports?
There's no prohibition against the committee doing a minority report, and I've thought the same. Yep, that's possible.
Just looking at the landscape here and what we're going to be talking about between now and then of the year, I just wondered. I did not know whether but I do think the leadership of the commission need to determine, just as the legislatures have, what does it take to have a minority? I mean, what is the process for creating such a report, right, if that needs to be done? So hopefully it won't need to be done, but
we should. It's one of those parliamentary procedure questions, and so we rarely, under which procedures do we operate in the absence of any rules per se, and that's a point well taken. I've thought about that a little bit, so we'll attend to it in the event it's necessary. All right, if there's nothing further, then for the good of the order, Lenise, I yield to you. Thank you.
Just one thing about the upcoming schedule. We have on the next meetings list to have a draft report on insurance versus surety bonds, but in yesterday's meeting, there was a request for some representatives of Commerce and Insurance and proponents of the bill to come speak to that issue. So with your indulgence, what we would do is bump the presentation of the draft report to the December meeting and a final report then in January for your approval.
Without objection. Good. Good, thank you. Nothing further for the good of the order? Going once, going twice? All right, we'll stand adjourned. Thank you. Thank you, Mr. McMahon. Happy birthday. I kept your...